federal agents surrounded a residential property in Studio City, Los Angeles on July 2nd, 2025, and placed one of boxing's most recognizable surnames in handcuffs.
Mexican boxer Julio Cesar Chavez Jr. has been arrested by ICE.
No me informan a mi abogado lo de cuando ya tengo una orden. Te vamos a llamar.
It wasn't just another sports scandal breaking across the internet. This was the moment, a story that had been quietly building for years behind closed doors, finally exploded into full international view. One of Mexico's most celebrated sporting dynasties had collided head-on with the United States federal justice system, and the shockwaves reached all the way from Hollywood to Mexico City to the mountains of Sinaloa. I mean, the name alone, Chavez, carries the kind of weight in Mexico that transcends boxing. It lives inside the national consciousness. It's painted on walls, spoken in arenas, whispered in reverence by anyone who grew up watching Mexican boxing during its golden era. Taxi drivers know that name. Grandmothers know that name. Children in small towns across Sinaloa, Jalisco, and Chihuahua know that name. It is not merely a sporting identity, it is a cultural institution that spans generations and crosses every economic and social boundary in the country. But what I'm about to walk you through isn't just the story of a boxer who fell from grace. This is something far more layered, far more dangerous, and far more revealing than anything his career inside the ring ever produced. And here's the thing. I'm not going to give you everything up front, 'cause the way this story actually unfolds, piece by piece, is what makes it so extraordinary. What I will tell you is this. There is a visa that expired and was never renewed. There is a green card application that federal authorities say was built on fraud. There is a December 2024 government designation that should have ended everything immediately, but didn't, because of a political decision that raises its own serious questions. There is a Mexican arrest warrant tied to allegations that reach all the way into the operational heart of one of the most powerful criminal organizations on earth. There is a 2024 arrest in Los Angeles for weapons charges so specific they read more like a cartel logistics issue than a personal firearms matter. And then there is the marriage, one union to one woman, whose family history connects the Chavez name to El Chapo's bloodline in a way that federal investigators in two countries found impossible to ignore. I assure you the real story lies in the details the media conveniently glosses over. The classified designations, the timeline of entries and exits that authorities say were anything but accidental, and the family connections that stretch back decades before Chavez Jr. ever threw his first professional punch. But amidst all of that, the warrants, the deportations, the cartel structures, and the cross-border prosecutions, this entire story traces back to one decision, one marriage, one connection. And once you understand the full picture, you won't see the Chavez name the same way again. Before we get into the heart of what's happening right now, I need you to first understand exactly who Julio Cesar Chavez Jr. is, where he came from, and why the pressure that surrounded him from the moment of his birth made his story almost inevitable. Julio Cesar Chavez Jr. was born on February 14, 1986, in Culiacan, Sinaloa, a city that carries its own extraordinary significance in the modern history of organized crime. He entered the world not as a blank slate, but as the son of a living legend. His father, Julio Cesar Chavez Sr., was at that precise moment in the middle of one of the most dominant runs in professional boxing history, and the weight of that legacy settled onto the son before he was old enough to throw a punch. Growing up in a household where championship belts were household objects and world-famous fighters passed through regularly, the younger Chavez absorbed boxing the way most children absorb language, passively, constantly, and without the option to simply opt out. His father won the WBC and WBA super featherweight titles, the WBC lightweight title, and the WBC super lightweight title during the 1980s and 1990s, compiling a record that reached 89 consecutive fights without a loss. The standard the son inherited was not merely difficult to meet, it was suffocating. Chavez Jr. turned professional in 2003 at just 17 years old, beginning in the lightweight divisions before eventually working his way up through the weight classes. He fought regularly throughout the mid to late 2000s, building a record that climbed steadily toward respectability. Promoters pushed him aggressively, not entirely based on his raw talent alone, but also because the Chavez name guaranteed ticket sales, television ratings, and the kind of cross-border Mexican audience that every major boxing promotion wanted to capture. In 2011, the moment that was supposed to define his legacy finally arrived. On June 4, 2011, Chavez Jr. defeated Sebastian Zabik by unanimous decision to capture the WBC middleweight championship of the world. The victory was celebrated intensely across Mexico. Here, many believed, was confirmation that the dynasty would continue. The son had done it. He had delivered the championship his bloodline promised. But here's where it gets complicated, and it got complicated fast. Almost immediately after winning the WBC title, cracks appeared that could not be ignored. Weight management became his most visible enemy. Middleweight boxing requires competing at 160 pounds, and Chavez Jr. consistently struggled to make that limit with any discipline. Before his mandatory defense against Sergio Martinez in September 2012, the weight situation reached crisis levels. He was stripped of 2 points during the fight itself for low blows, in addition to the mounting punishment Martinez administered, and he was ultimately stopped in the 12th round after having been dropped and battered throughout the contest. We know plenty of champions have lost their titles. But this? Nah. Now this was different in its totality. A 37-year-old Martinez had dismantled him so thoroughly that boxing analysts questioned whether Chavez Jr. had any business being in that ring at all. The loss was not a close decision or a career detour. It was a complete exposure of the gap between the Chavez brand and the Chavez reality. The aftermath of the Martinez defeat set the tone for everything that followed. Chavez Jr. received a suspension after testing positive for a banned substance, specifically marijuana metabolites, following the loss. The Nevada State Athletic Commission suspended him for 9 months. When he returned, the inconsistency and unpredictability that would come to define his career became permanent fixtures. He won some fights against opponents who were carefully selected, but whenever he faced legitimate elite-level competition, the results consistently revealed the same problems: weight discipline failures, lack of conditioning, unprofessional preparation, and an apparent inability to perform under pressure. He was stopped by Andrzej Guta in a fight many observers found deeply embarrassing for a former world champion. He suffered losses to Daniel Jacobs and to David Lemieux, both of whom exposed his defensive liabilities and diminished hand speed. Against Canelo Alvarez in May 2017, in what was marketed as a mega fight and a generational Mexican rivalry, he was completely outclassed and stopped in the 6th round, the performance confirming that whatever potential had once existed had by then been comprehensively wasted. Failed drug tests continued to interrupt whatever momentum he occasionally manufactured. He was suspended again after testing positive for a diuretic, specifically furosemide, which is commonly associated with cutting weight, and in combat sports, its use raises immediate questions about a fighter's overall approach to professional competition. But did any of that stop the controversies? Well, no. Instead, it only made the accumulation of red flags around his name grow heavier. Each suspension, each failed test, each embarrassing performance subtracted more credibility from his public standing. And by the early 2020s, Chavez Jr. had transitioned from a fallen champion into something closer to a cautionary tale about squandered potential. His name still generated headlines, but the nature of those headlines had shifted entirely from celebrating victories to documenting controversies. And then came Jake Paul. On June 28, 2025, Chavez Jr. stepped into the ring against social media personality and professional boxer Jake Paul in a fight held at Honda Center in Anaheim, California, broadcast to a massive global online audience. The result was a defeat, with Paul winning by unanimous decision and Chavez Jr. looking every bit as diminished as his recent record suggested he would. He came in significantly over the agreed catch weight, reportedly weighing above the contracted limit, drawing criticism from Paul's camp and boxing media alike before the first bell even rang. The performance itself was lethargic, uninspired, and further confirmed that whatever remained of the athletic force that had once won him a world title was now largely gone. For most observers, the fight was simply another sad chapter, a former champion reduced to a credentialed opponent for a YouTube star's boxing journey. What almost nobody realized in that moment was that federal immigration authorities had been quietly reviewing his legal status in the United States for some time, and the visibility of that televised event placed him squarely in a spotlight that accelerated the timeline of what was already coming. Now listen closely, cuz what I'm going to say next brings everything together. Because the immigration story did not begin in July 2025. It began in August 2023, when Chavez Jr. entered the United States on a B2 tourist visa. That visa carried a standard expiration date of February 2024. He did not leave when it expired. Instead, on April 2nd, 2024, his legal team filed a green card application on his behalf, based on his marriage to a U.S. citizen. Under normal circumstances, filing for adjustment of status can provide a legal bridge while the application is processed. But federal authorities allege that the statements made during that application process were fraudulent, that the picture of his circumstances presented to immigration officials did not accurately reflect the reality of who he was, what he was doing, and what federal investigators already knew about him. Because here is what was happening behind the scenes while that green card application sat in processing. On December 17, 2024, the Department of Homeland Security formally designated Julio Chavez Jr. as an, and this is their language, egregious public safety threat. That is not a routine designation. That is a specific federal determination that an individual poses a serious enough danger that their continued presence in the country constitutes an active risk. Under the Biden administration, which was still in office at that point, Diaz made that designation, but did not prioritize his removal. He was not arrested. He was not deported. He remained in the United States despite the government's own internal assessment of the threat he represented. That political decision to flag him and then not act became one of the more quietly significant details in the entire timeline of this case. Then, on January 4th, 2025, Chavez Jr. Ray entered the United States through the San Isidro Port of Entry, one of the busiest border crossings in the world, connecting Tijuana to San Diego. He came back in despite the outstanding DACE designation. And then, on July 2nd, 2025, just 4 days after the Jake Paul fight concluded, agents from ICE and DACE moved to Studio City, surrounded his residence, and placed him under arrest. The initial federal charges focused on the visa overstay and the alleged fraudulent statements in the green card application. But what surfaced during the processing of those charges was something that immediately elevated this case to a completely different level of international significance. Mexican federal prosecutors had an active arrest warrant on file for Julio César Chávez Jr., and that warrant had been building since 2019. Mexico's Attorney General Alejandro Gertz Manero confirmed that the investigation into Chávez Jr. had originated that year, making it a years-long federal inquiry that predated his U.S. immigration violations by nearly half a decade. The nature of the allegations within that warrant were not related to tax issues or contract disputes. According to statements from the Department of Homeland Security cited in multiple outlets covering the arrest, Mexican authorities alleged that Chávez Jr. maintained documented links to individuals associated with the Sinaloa cartel's security and logistics structure. We know public figures in Mexico occasionally face politically motivated legal pressure, but this? Nah. Now this was unprecedented in its specificity. These were not vague accusations framed around general association. They were tied to an active federal arrest warrant naming organized crime participation, arms trafficking investigations, and drug trafficking allegations as the substantive legal foundation for extradition-level criminal proceedings. And the U.S. criminal record made things even harder to dismiss. In 2024, before the federal immigration arrest, the Los Angeles Police Department had arrested Chávez Jr. on charges of illegal possession of an assault weapon and manufacture of a short-barreled rifle. These were not vague or minor weapons charges. The specific nature of those allegations, the type of weapon, the manufacturing angle, are the kinds of details that federal investigators examining cartel logistics connections would find particularly significant. A short-barreled rifle is a federally regulated weapon in the United States. Its manufacture without proper licensing is a federal crime. The Lapt case added a separate, concrete U.S. criminal matter to a profile that was already under intense federal scrutiny. You see, the Sinaloa cartel is not a fringe organization or a minor regional gang. It is widely identified by the DEA and the U.S. Treasury Department as one of the largest and most sophisticated transnational criminal organizations in the world, responsible for moving enormous quantities of narcotics into the United States and operating across dozens of countries. Mexican federal prosecutors, according to information provided to U.S. authorities as part of the cross-border legal proceedings, alleged that Chávez Jr.'s connections extended into the cartel structure in ways that went beyond casual social contact. The allegations encompassed suspected involvement in organized crime participation, with additional references to ongoing investigations involving arms trafficking and drug trafficking that formed the substantive basis of the Mexican arrest warrant. Mexican agencies, including the Fiscalía General de la República, the country's primary federal prosecutorial body, were identified as the institutional drivers behind those charges. Under Mexican federal law, if convicted on those charges, Chávez Jr. faces up to 40 years in prison, a sentencing exposure that transforms this from a headline story into a genuine life-altering legal reckoning. The legal significance of an active Mexican federal arrest warrant in the context of a U.S. deportation proceeding is substantial. When a deportee faces outstanding criminal charges in their country of citizenship, repatriation typically results in immediate judicial processing in the receiving country rather than simply being allowed to walk free upon landing. That is precisely what happened. Former Mexican President Claudia Sheinbaum publicly confirmed that Chávez Jr. had been deported from the United States back to Mexico, following the completion of the expedited removal proceedings initiated by ICE. Upon his arrival in Mexico, he was not released. He was transferred into federal custody in the state of Sonora, where the legal process connected to the outstanding warrant began immediately. Mexican courts conducted formal hearings to evaluate the charges and determine how proceedings would advance. A federal judge reviewed the allegations and issued a ruling requiring Fez Jr. to stand trial, a significant legal determination, confirming that the court found sufficient foundation in the presented evidence to proceed toward formal prosecution rather than dismissing the case at the preliminary stage. However, the judge also determined, based on the specific circumstances and the legal arguments presented, that he would be permitted to await trial outside of active prison detention while remaining under strict judicial supervision. This arrangement, known in the Mexican legal system as a supervised release pending trial, placed him under court-imposed monitoring conditions while the case advanced through the judicial process. If you take the time and do your homework, you can find out that his legal defense team responded to these developments with an aggressive and vocal public posture. His attorney, Michael Goldstein, speaking to Mexican and international media, strongly rejected the substance of the cartel allegations. Goldstein publicly called the prosecution another headline to terrorize the Latin community, a pointed statement that framed the case not merely as legally questionable, but as ethnically and politically motivated. The defense argued that the accusations connecting Chavez Jr. to the Sinaloa cartel were not grounded in provable criminal conduct, but were instead built on rumor, association by proximity, and what they explicitly described in press statements as urban legends that had circulated around the Chavez family for years without ever producing charges. Defense attorneys also pushed back on the specific arms trafficking and drug trafficking references embedded within the Mexican warrant, arguing that the allegations lacked the direct evidentiary foundation required under Mexican federal criminal procedure to sustain a conviction. They emphasized that suspicion of association, even documented social interaction with individuals later identified as cartel-connected, does not constitute criminal participation under either Mexican or American law. The legal team's public strategy appeared aimed at managing the narrative in both countries simultaneously, while the formal judicial processes proceeded on their separate tracks. But ironically, the moment his legal situation became public, the story that dominated headlines was not really about immigration procedures or even the specific cartel allegations. The story that exploded across every major media platform was about a woman, specifically about who Julio Chavez Jr. had married. His wife, Frida Muoz, is a figure whose personal history immediately became the central focal point of international media attention once her connection to the case surfaced. Frida Muoz is a Mexican socialite and public figure who had previously been in a relationship with one of the sons of Joaquin Archibaldo Guzman Loera, known globally as El Chapo, making her the mother of one of El Chapo's grandchildren. That documented family connection, already well known in certain Mexican media circles before the arrest, became explosive context once Chez Jr.'s cartel allegations became public. Critically, the son of El Chapo, with whom Frida Muoz had that relationship, is now deceased. A detail that matters for understanding the current family structure, but that did nothing to diminish the intensity of media and federal scrutiny once the connection was reported. El Chapo's story needs no extensive introduction, but the family structure surrounding him is crucial context here. Guzman was arrested for the final time in January 2016, extradited to the United States in 2017, convicted in February 2019 by a federal jury in Brooklyn on all 10 counts against him, including engaging in a continuing criminal enterprise, conspiracy to launder narcotics proceeds, and use of a firearm, and sentenced to life in prison plus 30 years. His sons, collectively known in Mexican media as Los Chapitos, including Joaquin Guzmán and Ovidio Guzmán, have been repeatedly identified by U.S. and Mexican authorities as active leaders within the Sinaloa cartel's current operational structure. Frida Muos's prior relationship with one of these individuals, and her status as the mother of El Chapo's grandchild made her presence in Chavez Jr.'s life, and the marriage itself, a detail that federal investigators and media outlets found impossible to ignore. It is important to be precise about what is publicly documented and what remains in the realm of allegation. The marriage between Julio Chavez Jr. and Frida Muos is a confirmed public fact. Her previous relationship with a now deceased son of El Chapo, and her status as the mother of that child is documented and acknowledged in Mexican media reporting and public records. What federal authorities alleged, specifically, whether the marriage or the family connection it created played any role in the cartel association allegations contained in the Mexican arrest warrant, was not fully detailed in the public statements released by either U.S. or Mexican authorities. The connection was noted by investigators and widely covered in reporting, but the specific legal theory linking the marriage to criminal conduct remained a matter of ongoing judicial proceedings rather than proven fact. Now, while all this was unfolding in courtrooms and federal offices, one man was watching from the outside with a particular kind of pain that no one else in the world could fully share. Julio Chavez Sr., the father, the legend, the man whose name started all of this, had publicly commented on his son's legal situation in interviews that circulated across Mexican and American media. He expressed profound concern, described the experience of watching his son face criminal allegations as emotionally devastating, and stated his hope that the judicial process in Mexico would produce a fair and truthful outcome. He did not deny that the situation was serious. He also did not abandon his son publicly, maintaining a posture of parental support while carefully avoiding statements that could be interpreted as dismissing the severity of the legal proceedings. But here's the thing. Chavez Sr.'s own history added an unavoidable layer of complexity to the public conversation surrounding his son's case. Because Chavez Sr. himself, over the course of his legendary career, had made remarkably candid public admissions about the social world he inhabited during his boxing prime in the 1980s and 1990s. In interviews given over multiple decades, Chavez Sr. acknowledged spending time around powerful drug traffickers who were drawn to him because of his extraordinary celebrity status throughout Mexico. He described encounters with major cartel figures at private events, public celebrations, and social gatherings as a natural consequence of his cultural prominence during an era when organized crime figures moved freely through elite Mexican social circles. One of the most striking public admissions Chavez Sr. ever made came in his own retelling of the celebration following his 1992 fight against Hector Macho Camacho, a victory that was one of the defining moments of his legendary career. Chavez Sr. acknowledged that among the guests at his post-fight party that evening were some of the most powerful and dangerous figures in Mexican organized crime at the time, including El Chapo himself, El Mayo Zambada, Amado Carrillo Fuentes, El Hero Palma, Juan Jose Esparragoza, and the Arellano Flix brothers. These were not peripheral figures or minor associates. They were, collectively, the architects of modern Mexican cartel power. To have that guest list at a boxing celebration in 1992 is a window into just how completely the worlds of elite sport and organized crime intersected in Mexico during that era. Crucially, Chavez Sr. consistently maintained in these same interviews that he never participated in criminal activity and was never charged with any cartel-related crime. His position was always that social relationships in the context of Mexican celebrity culture during that specific historical period must be understood differently from criminal association or organizational participation. He distinguished between encounters at events and active involvement in criminal enterprise, and no criminal charges were ever brought against him related to those acknowledged social relationships. These public admissions resurfaced immediately and intensely once his son's arrest became international news, forcing media outlets and audiences to examine the entire Chavez family narrative through a new and considerably darker lens. To put that into proper historical context, the relationship between professional boxing and organized crime in Mexico during the 1980s and 1990s was not a Chavez-specific phenomenon. It was a structural feature of the cultural moment. Mexico's boxing champions during that era achieved a level of national celebrity that transcended sport entirely. They were cultural ambassadors, national symbols, and social phenomena whose popularity extended into every layer of Mexican society, from the poorest neighborhoods to the presidential palace to the heavily fortified compounds of men who ran some of the most powerful criminal organizations in the Western Hemisphere. Major cartel leaders of that era, including figures from what would eventually be identified as the Guadalajara Cartel and the organizations that emerged from its fragmentation, regularly sought proximity to famous athletes, entertainers, and public figures as part of both their social ambitions and their strategic cultivation of public legitimacy. Several prominent Mexican athletes of that generation have publicly or privately described encountering powerful criminal figures at social events without necessarily understanding the full nature of those individuals' criminal operations at the time. Some encounters were entirely involuntary, being approached at a public celebration, being given gifts or tributes that refusal could make dangerous in certain contexts. Others were more deliberate social arrangements in which the athlete's famous presence was exchanged for financial sponsorship or access to resources. The economics of Mexican boxing during that era also created structural vulnerabilities. Prize money from major championship fights was substantial by the standards of the sport, but promotional deals, endorsements, and the infrastructure supporting a world champion's career often ran through informal networks of wealthy backers whose own financial origins were not always transparent or entirely legal. The historical complexity of this environment does not excuse criminal conduct where it genuinely occurred, but it provides essential context for understanding why decades of speculation have surrounded multiple prominent Mexican athletes without necessarily producing criminal charges in every case. The media coverage surrounding Chavez Jr.'s arrest and the subsequent legal developments illustrated in sharp relief how differently the same set of facts can be presented, depending on the outlet and cultural context. American media, including major sports journalism outlets and immigration-focused reporting, emphasized the federal immigration charges and framed the story primarily through the lens of ICE enforcement and green card fraud. Outlets like ESPN and The Athletic ran detailed timelines of his immigration history and cross-referenced the cartel allegations with publicly available DIA and Treasury Department material on the Sinaloa cartel's operations. Mexican media split broadly between coverage that treated the cartel allegations as credible and significant and coverage that was more sympathetic to the Chavez family narrative, with some outlets openly questioning whether the timing and intensity of the prosecution was politically motivated by actors on either side of the border, seeking to use a famous name for their own purposes. Social media accelerated every element of this division. On platforms like X, formerly Twitter, and across YouTube and Instagram, the story was reduced in many instances to its most sensational elements: the El Chapo connection, the cartel allegations, the arrest footage, and viral posts accumulated millions of views within hours of the initial reporting. Legal analysts appearing on American and Mexican television programs cautioned repeatedly that the existence of an arrest warrant and a judicial determination to proceed to trial are not the same as a conviction, and that the specific evidentiary standards required to actually prove the cartel association allegations had not yet been tested in open court. Those distinctions competed poorly against the narrative momentum generated by the combination of the Chez name, the El Chapo connection, and the word Sinaloa appearing in federal documents. Boxing commentators and the broader combat sports media found themselves in the uncomfortable position of having to contextualize a story that had moved entirely beyond the sport they covered. Analysts who had spent years documenting Chavez Jr.'s professional decline suddenly found that audiences wanted them to explain Mexican cartel structures and immigration law rather than fight technique and training camp discipline. The question of boxing legacy is one that gets complicated very quickly when you try to apply it honestly to Chavez Jr.'s career. The WBC middleweight championship he won on June 4th, 2011 against Sebastian Zabik was a genuine world title won against a legitimate champion. That is a factual achievement that belongs in any honest accounting of his career. But it is equally true that his reign as champion was brief, troubled, and ended in a comprehensive defeat at the hands of Sergio Martinez before he had successfully defended the belt against a series of elite challengers. The subsequent years produced a record that mixed victories over carefully managed opposition with losses against anyone operating at genuinely elite levels. The failed drug tests, the marijuana suspension in Nevada, the furosemide violation, each added a permanent asterisk to his record. What those legal and disciplinary records reveal cumulatively is a picture of a man who never fully committed to the professional standards his father's name demanded. Whether that failure of commitment was rooted in the psychological weight of that impossible surname, in personal struggles that were occasionally discussed in media coverage, in the social environment he inhabited, or in some combination of all three, it produced a career that ultimately fell far short of the destiny that appeared to await him in 2011. And now, whatever conclusions audiences might have drawn about that career, sympathetic or critical, have been permanently complicated by the federal arrest, the cartel allegations, the deportation, and the ongoing criminal proceedings in Mexico that dominate his public story today. How exactly did a fighter born with every conceivable advantage, the famous name, world-class training access, promotional backing, and an automatic audience, end up here? Well, understand that we need to first acknowledge that the advantages themselves may have been part of the problem. When the name does more promotional work than the fighter's own discipline, that discipline becomes optional in ways that eventually prove catastrophic. Every professional boxing career requires sacrifice, and the willingness to sacrifice is most reliably produced by need. The need to prove something, to earn something, to fight your way to recognition that would otherwise be unavailable. For a fighter born already recognized, already promoted, already famous by association, that necessary hunger becomes nearly impossible to manufacture authentically. According to multiple sources covering the case across both countries, the criminal proceedings in Mexico were advancing through their preliminary stages as of the latter part of 2025, with no indication that the charges would be withdrawn or the warrant vacated. The specific timeline for a trial, given the pace of the Mexican federal judicial system and the complexity of the allegations, remained uncertain. His legal status under judicial supervision meant he was not imprisoned, but was also not free in the full sense, bound by court conditions, required to appear before the court regularly, and facing the ongoing reality that the most serious chapters of the legal process had not yet begun. Few developments reported from inside the proceedings suggested the prosecution intended to narrow the scope of its allegations. Some reporting from Mexican legal sources indicated that investigators had gathered testimony and documentary evidence they believed linked Chavez Jr. to specific individuals named in the Cartel Association allegations, while his defense team continued to assert publicly that such evidence, upon full examination in court, would prove insufficient to support the charges. Now here's where it gets particularly significant, because this case is not replicable. The conditions that made it this extraordinary, this globally watched, and this legally complicated are specific to a convergence of factors that cannot be exported to any other story in modern sports. Break it down, and you start to understand exactly why. First, the Chavez surname does not simply represent boxing fame. It represents the single most recognizable dynasty in Mexican combat sports history, which means every development in this case carries national cultural weight that no ordinary athlete's legal troubles could generate. Second, the specific geography of Chez Jr. as birth and upbringing. Culiac, Sinaloa, the operational heartland of the cartel named in his arrest warrant, means that his personal biography intersects with the subject matter of the allegations in a way that is structurally unique and almost impossible to dismiss as coincidence from a narrative standpoint, regardless of what courts ultimately find. Third, the Frida Muoz marriage introduced a documented bloodline connection to El Chapo's family that no other athlete in the world can claim, making the web of alleged associations impossible to disentangle from the most famous organized crime prosecution of the 21st century. And fourth, the cross-border jurisdiction of the case, simultaneously involving ICE, the Fiscalía General de la República, and the Mexican federal court system, created a legal architecture of unprecedented complexity for a professional athlete's criminal proceedings. If other public figures tried to replicate the level of international attention this case generated, they would be more likely to reproduce only its scandal without any of the underlying structural factors that made it historically significant. It is, in that specific sense, a story that could only have happened to this family, in this city, connected to these people, at this particular moment in the history of Mexican organized crime and American immigration enforcement. The broader implications of this case extend well beyond one boxer's legal troubles. It raises questions about what celebrity protection has historically shielded from scrutiny in Mexico. It raises questions about how immigration enforcement priorities are determined and applied in the United States, and specifically, what it means when the government designates someone an egregious public safety threat in December and then allows them to re-enter the country through a major international border crossing in January. It raises questions about where the line between social proximity and criminal participation actually runs in environments where organized crime operates openly within elite social circles. And it raises questions about how generational legacy functions, whether the associations or simply the proximity of one generation can define the next across decades. Chavez Sr. built his legacy through an almost superhuman level of dedication to professional excellence. He fought 89 consecutive fights without a loss from 1980 to 1993, a streak that stands as one of the most remarkable achievements in combat sports history. He unified titles across multiple weight divisions, fought in front of sold-out stadiums across Mexico, the United States, and internationally, and became a figure whose cultural significance during his prime is genuinely difficult to overstate. His career was the foundation upon which the entire Chavez family public identity was constructed, a foundation of discipline, sacrifice, and excellence that his son, by almost universal assessment, failed to build upon adequately. That the father's acknowledged social proximity to cartel figures during his championship years, never criminally prosecuted, carefully distinguished from actual criminal participation in his own public statements, should then reappear in the story of the son's cartel allegations is one of the more haunting narrative threads running through this entire case. It is not evidence of guilt. It is not a criminal charge against Chavez Sr. It is, however, a pattern of proximity that has now spanned 2 generations in the same family. And here's something no one actually talks about enough in the mainstream coverage of this case. The fact that the legal proceedings currently underway in Mexico are not producing outcomes in real time, the way social media coverage implies. Mexican federal criminal cases of this complexity, involving cartel association allegations, multiple government agencies, cross-border evidence gathering, and high-profile defendants, routinely take years to reach final verdicts. The determination that Chavez Jr. must stand trial was a preliminary judicial ruling, not a conviction. The actual evidentiary contest between the prosecution and the defense has not yet been conducted in open court. Whatever conclusions audiences around the world have already drawn based on the allegations, the warrants, the deportation footage, and the El Chapo family connection, the legal truth of what Julio Chavez Jr. did or did not do in relation to the Sinaloa cartel has not been determined by any court. That distinction matters enormously, even in a story this sensational. The presumption of innocence exists as a legal and moral standard precisely because allegations, however serious and however backed by documented associations, are not the same as proven criminal conduct. The United States and Mexican federal judicial systems both operate from that foundational principle, regardless of what any headline asserts or what any viral social media post concludes. A warrant is a document reflecting a prosecutor's allegation. A ruling to proceed to trial is a procedural finding. A verdict is the thing that matters legally, and that verdict does not yet exist in this case. The public has already judged this story based on associations, names, and dangerous proximity to power. The court will judge it strictly based on evidence, testimony, and the law, and that process is just beginning. What is not in dispute, what no court proceeding can alter or reverse, is the trajectory of the story as it stands today. A man who was born into perhaps the most celebrated boxing family in Mexican history, who achieved a genuine world championship title in 2011, who squandered that achievement through a combination of personal failures, professional indiscipline, and a series of choices that repeatedly prioritized the wrong things over sustained excellence, now finds himself fighting a legal battle in two countries that dwarfs every fight he ever had inside a boxing ring in terms of consequence, complexity, and personal stakes. He is not fighting Sergio Martinez or Canelo Alvarez or Daniel Jacobs. He is fighting the governments of Mexico and the United States simultaneously, with an active criminal case producing evidence and testimony that will determine whether the cartel association allegations can be proven to the standard required for conviction under Mexican federal law, a standard that, if met, carries a sentence of up to 40 years. Chavez Jr.'s gone from that ring, but we don't think his story is done being written, not by a long stretch. What began as the tale of a son who could not escape the shadow of a legendary father has become something far more complex, far more consequential, and far more revealing about the world in which professional boxing's biggest names have historically operated in Mexico. The collision between sports and organized crime, between celebrity and criminal accountability, between generational legacy and individual failure, this case puts all of that on display in a way that is impossible to look away from and equally impossible to reduce to a simple verdict before the courts have spoken. One of boxing's most famous surnames, once synonymous with championship excellence, is now being argued over in federal courtrooms in two countries. Immigration lawyers are being asked to comment on the same story that cartel analysts and boxing historians are analyzing simultaneously. That is the measure of how extraordinary and how unprecedented this situation actually is. The only question left to answer right now is what a Mexican federal judge will ultimately find when the full evidence is placed before the court. whether the cartel association allegations survive rigorous cross-examination, whether the documented family connections cited by prosecutors constitute actual criminal participation or simply dangerous proximity, and whether a man who spent his entire career failing to live up to one legendary name will now be permanently defined by his alleged connections to another. The court will decide, but the world is already watching.